Hello, good morning. Oh, good afternoon. I'm still in the morning. Good afternoon. Sorry about that. Trying to keep up. Trying to keep up. Oh, good afternoon. How are you? How you feeling? We were here yesterday, but we're here again today because a lot is going on. Okay. If a lot is going on, we have to come here to discuss. Let me know in the comment section, where are you? How you feeling? Uh, Let me know in the comment section. We want to talk about what is really going on. A lot is going on. But you just have to know what exactly can you do, right? So I'm trying to share this on copy link. Anyway, I'm trying to share this on IG. By the way, if you're here, please let us know where are you from, watching us from, what you're doing. We want to talk about the latest immigration news. Meanwhile, I like to share my video so that people can just join and ask the question live, because I answer those questions live. Okay. Okay. First news first. Let's get right into it. Okay. So let me share my screen here. Let me get right into it. Yeah. BIA reinstates matter of Laparra and holds compliant notice of hearing support in absentia order despite defective notice to appear. This is weird, right? So what's going on nowadays? A lot is going on with the BIA. The BIA will find anything to stop you from winning, regardless. Like nowadays, all the decisions coming from the BIA, it's just like unheard of. But anyway, this is what they're saying. Let me finish sharing. This is my last sharing. Okay. So this is what they're saying. Essentially, what's happening is this. When the order a person remove in absentia, the person can go back and reopen their case if they have good cause. Good cause can be my notice to appear was defective. That's why I couldn't show up. I was sick physically in the hospital. This is proof. I couldn't, even if I wanted to, I couldn't be there. This is where I was admitted at the hospital. While my lawyer failed to give me the notice, then you ineffective of assistance of counsel. Well, there are a lot of good cause that can be shown so that you can reopen your case and be heard again, because they order you in absentia. You have to show good cause. If there's no good cause, that's all. You fail to show up in court, you be order removed in absentia, and you have a 5 years bar from adjustment of status. Some people even have 10 years bar from adjustment of status just for failing to show up. But the general rule is 5 years. Okay. But anyway, even when you become eligible for adjustment of status, you still have to go back and file a motion to reopen and hope it gets granted. Mostly at that time, the time has already lapsed. Then you try to join the motion with ICE, and hopefully ICE is going to reopen your case, and then you can, adjust your status. So that's how it works. But here, what they're saying is this: if you receive a notice to appear and you did not show up, the order you remove, then you come back and say the reason I didn't show up is because the notice to appear was defective, saying that is the notice to appear says time to be set. So basically the time and the date to be set, the date and the time to be set. However, later on they send you a second notice with the actual time, because remember here they say time, date and time to be set, which means they're gonna give you a date, and later on they send you a second notice with a time and the date, but you don't show up because you're still claiming that the first notice lacks time and date. No, it's not gonna work. They're still gonna maintain the order of removal. You can't just bring that as a defense, because they send you a subsequent notice with the time, because remember they say here date and time to be set, and later on they send you the second one. So this is what's going on with this case. Basically, the respondent who was initially served with a notice to appear at a date and time to be set was properly served on March 19, 2020, March 19, 2010, with a notice to appear scheduled for April 8, 2010 at I-130, sorry, 1:30 p.m. I-130, I'm so used to those I-130 petitions, sorry. But anyway, so the person was first, they sent him a notice saying that, notice to appear saying that a date and the time to be set. Then they will set the time and the date later, but they already sent you notice to appear. However, then they send a second notice with the hearing scheduled April 8, 2010 at 1:30 p.m. That person didn't show up in court, and then he was ordered removed for failing to appear. So now the lawyer went with subsequent motion to reopen to terminate for lack of jurisdiction, to reopen proceeding, to rescind the absentia order for lack of sufficient notice. The First Circuit denied. Basically, they granted petition for review in part. So the court agreed with the jurisdictional ruling, but remanded the case for further proceedings after holding that where the initial notice to appear lacked a date of it and the time, and subsequent notice of hearing cannot support an absentia removal order because it cannot provide a new time and new place for the proceeding. However, the Supreme Court has already decided on this issue, right? And held that a respondent served with a notice to appear that lacks a date and time may be ordered removed in absentia, okay? If that respondent receive a notice of hearing under section and subsequently fail to appear at the hearing because the notice of hearing can be provided a new time and place of the proceedings, okay? So basically, they give you the first notice. It says time to be set, date and time to be set. Then they give you another notice with the date, notice of hearing, notice to appear, and then notice of hearing with the date and the time. You have to show up. You can't claim that the notice to appear was defective. It's not going to work because they provide you with the notice of hearing, which is compliant. So you just have to show up. So that's what they're saying, that it's not, yeah, it's not going to work like that. So this, and then the BIA just go back to how the last, matter of Laparra. Let me stop right here, first of all. Yeah. So do you have a question about this one? Do you have a question for this one? Do you have a case for this? Do you have a question for this one? So before we move on. Let me know in the comment section if you have a question before we move on. If you have a question, let me know in the comment before we move on to the second. Before we move on to the second news. Before we move on to the second news, if you have a question. Okay, let's move on. Since you don't have a question, let's move on to the second news. Okay, the second news is here. This, we already talked about it yesterday. Immigrant visa processing update for nationality at high risk of public benefit usage. So basically what they're saying that immigrant must be financially self-sufficient and not be a financial burden to American. So that's why they're pausing those immigrant visa issuance, because they want to find out whether the person is going to be public charge or not. Okay, if most likely the person is going to rely on public benefits, Medicaid, food stamp, public housing, those type of benefits. So they want to investigate more. So that's what they're saying. It says the Department of State is undergoing a full review of all policies, regulation, and guidance to ensure that immigrants from this high-risk country do not utilize welfare in the United States or become a public charge. Okay, that's what the pausing of visa issuance, immigrant visa applicant who are those are the country a lot 75. Even my home country is here. Democratic Republic of the Congo, it's here too. We have a lot of African countries, sorry. A lot of African country, Cameroon, all those Cote d'Ivoire, yeah, Ghana, even the Caribbeans too, like Jamaica, Haiti, Guatemala, and America, Latin America, Guatemala, and stuff like that. So a lot of countries. You can just go on the department travel.state.gov, U.S. Department of State. You see the entire list. Okay, that we talked about it yesterday, but I want to go back to another news today. Let me go back to the news. Meanwhile, if you have a question, just please put it in the comment section because we're here to answer those questions. Sorry. I want to go to another news. You might know this one. This one is kind of sad. This one. Hold on. Let me get into it. Give me one moment. Let me get into it. Okay. This one. Pretty sure. I don't know if you remember this guy. And put it a little bigger. Okay. Anyway, so do you have a question? If you have a question, please put it in the comment section. Okay, if you have a question, please put it in the comment section. Nobody has a question. It's too early, right? Too early for this, for those bad news. Remember this guy, Khalil? This guy made like breaking news when they started those raids and arrests on students that were protesting. Remember when Palestinians had a war going on? So people were protesting and they started arresting people. So this guy got arrested and he was ordered removed, basically. And he was between court and stuff like that. And he was ordered released, but now they're saying he can be detained again. The Third Circuit finds Khalil can be detained again. The Third Circuit on Thursday vacated a series of New Jersey federal court orders that halted the removal of a Palestinian. They ordered him removed, but the removal was halted, like they stopped it. Palestinian American graduate student and order his release from immigration detention. So, but now the Third Circuit saying, holding that although the district court properly exercised habeas jurisdiction, the Immigration and Nationality Act stripped it of its authority to intervene in his removal proceedings. So basically, he can be detained again. This is the topic of redetention. Like, yeah, that's not good. Like a person can be redetained again. No. Like if you can't remove the person, you can't detain them again for what? Unless they committed another crime. Yeah. But anyway, that's what's going on right now. Yeah, I'm stopping here. Okay. Do we have additional questions? Let me go back and try to find out about other, if we have more news. Meanwhile, I'm just waiting for you to ask additional question before we. Okay, so we have this one. We already talked about it. Let's see. Okay, so let's see. Okay, we have questions. Let's start with question. Okay. Oh, sorry. Let me see. Hi. Hi, I have a question about my wife green card. She got here since September, but still waiting for the green card. What country are you from? What country are you from? Because if your country is on pause, they're not gonna give it until they lift the pause. If the case was pending, now the country is on pause. What Senegal? Senegal is now on pause, right? Senegal is on pause. Not of. I don't think about this new one, but before the new one. Let's see for the new one. Senegal is under this new, effective January 21st, 2026. The Department of State is pausing all visa issuance to immigrant visa application or national for country. But that's if the person was outside. But from the person who's here, you have to look into the ban. The 30 country that was under the ban, that's how you have to find out. Okay, so let me check. Okay, let me check under the first ban, 39 countries ban, if Senegal is there. Yeah, because under the ban, all country, like, it was paused. All their country. Let me see if I see Senegal. Yeah, partially restricted. So all applications since September. Yeah, she's already here. It doesn't matter. But remember that on January 14, right, they came up with another ban, adding 39 countries. And they said that they were going to pause all applications for those countries. I made a video about it. They're going to pause. That's why it's now, they don't, not like, yeah. So if the case is pending, unless you meet the exception, like national interest, if your case is for the national interest of the United States, then you can meet the exception, then they can process the case. If not, all those cases are on pause. Yeah, the cases are on pause. That's unfortunate. You just have to wait until they lift the first ban, the one that um, came out on January 14. Yeah. Okay. So since September, yeah. So unfortunately, because of the ban came out on um yeah, the when a case is pending and something comes up, then everything that, even the case that was pending, is just gonna go with the new policy. That's the unfortunate part. Yeah, just have to monitor the ban and see. I Yeah, they said they're gonna IR1. Hold on. IR1. Hold on, let me double check. Are you talking about IR1 visa? Immediate relative, spouse of. Yeah, all applications are on pause. That's what they said. At first, they said they're not gonna. They said they sent me a letter to pay fee for producing the card. Okay, I received it yesterday. Okay, pay the fees then. Maybe if you pay the fees, they're gonna give it to you. Yeah, but you never pay the fee. You said since September. How come you never paid the fee? I don't understand your issue. Immediate relative, spouse of immigrant visa for foreign spouse of U.S. citizen. I received the letter yesterday. You should call. First of all, you should just call them to find out what's going on. If your country is on ban and all the applications are on pause, then it's going to be on pause. But you can always call them since you received the letter yesterday. So, which probably means that they still, for the immigration. For the immigration. No problem. Thank you. Yeah, so who else has a question? We want to wrap up here. We talked a lot today. It's only morning. Anybody else has a question? We ask, oh my gosh, it looks like the weather is not good today. The wind is blowing. Anybody else has a question? If you have a question, anybody has a question so we can wrap up. I'm trying to see if there's another news going on when we're speaking. So anybody else has a question? If we don't have a question, please just go ahead, like, share. Anybody need the consultation, just schedule it. All the consultation links are on my bio description box. Thank you very much. We come back. Our actual sessions are Sunday 2 p.m. Eastern time, but because we're having a lot going on, that's why I came back again. Oh, okay. We have somebody here. Hold on. Defaulted you in order to get a green card. You should call USCIS. If you feel like it's fraud, you can call USCIS. This if you just Google how to report fraud, USCIS how to report fraud. You just Google and call them. Yeah, this is the email. This is the email where you report fraud. If you have, this is for H1B abuse. This one you can report. This is for H. Yeah, you can also call just USCIS and tell them that you would like to report fraud. Um, yeah, then you can report it. Then they're gonna do the investigation. Does it take long for them to investigate? Nowadays, because they want to investigate, they might not take that long. You have to have evidence, right? So if you're accusing somebody, you have to have evidence. So nowadays, they're doing things faster because they want to remove people. So you're just going to have to call them and tell them that you want to report fraud. They're going to tell you what to do, or you can email them too. They're going to tell you what to do. Then you're going to report it. I don't know how long it's going to take to investigate, but if you have a lot of evidence, they're going to investigate. Sometimes they take too long to investigate, but they find out. If they're going to find out something, they're going to find out. It can take 10 years, but they will find out. I don't know how long, to be honest. I don't know how long it takes, but yeah. Okay. Thank you very much. Thank you for showing up. Please like, please share. Until next time. Bye-bye. We'll be here Sunday, 2 p.m. Eastern time. Is it better that I send a sworn affidavit? Just try to email them first and tell them that you try to report fraud. What else do you need from me? Then they're gonna work with you because they want to know what's going on. They're cracking down on immigration. Try to call or email them to find out what they need from you in order to do that. Okay, thank you very much. Until next